The state has closed its case in the Senzo Meyiwa murder trial, prosecutors saying no more witnesses will be called after leading evidence for 3 years. 5 men are accused of killing the Bafana and Orlando Pirates captain back in October of 2014. Linda Mnisi joining us in studio tonight to wrap up the day's proceedings for us. Linda, good evening to you. It certainly is a major milestone, 3 years of leading evidence in what has been a marathon trial. Talk us through some of the highlights.
Yeah, well, it's 3 years, but technically 2, if you consider the fact that Judge Ratamo has been presiding over this matter since 2023. So July actually marked 2 years exactly under Judge Ratamo because you'd recall that Judge Maumela was fell ill and was also suspended by President Cyril Ramaphosa on separate allegations really and not related to Senzo Meyiwa. But under this current judge, the state has been leading evidence since 2023. And in these 2 years, there's also been, the trial within a trial, which on its own had a number of witnesses who took the stand. And it was quite significant. I've been saying throughout the day that if you look at when you want to talk progress, you look at the trial under Judge Maumela, you compare that with the trial under Judge Ratamo there was quite a number of witnesses that took the stand, even more than what we saw earlier in 2022 under Judge Maumela, under a short space of time. And largely that's because, obviously, during Judge Maumela's time, there wasn't a specific court and a specific judge there wasn't really a specific court assigned to this case, right? So Judge Maumela also had other matters that he was dealing with. So the matter would be postponed, 2 weeks later, next month, and so on and so forth. But in this particular instance, you've had a retired judge come in, presiding over this particular case, and really under all these circumstances, the turbulence, the twists, the turns, the changes in legal representatives, and even one having passing away, he's also led it to this particular point. But interesting that this marks an important point for the defense. Yeah. They have an option to either launch a 174 application, which is a discharge application. Essentially, they're saying that they would be saying that the state has not presented evidence, or there are no prospects of a conviction based on the evidence that the state has presented, and therefore there is no need for them to defend themselves. On those grounds, this case should be thrown out. Now, there can either be 2 outcomes in this regard: the court agreeing with them, which would mark the end of this case, and they can never be retried again on the same charges, regardless of what comes up. Secondly, it can say, no, there is enough evidence, and you can particularly continue with this trial. That means they would have to open their case, call their own witnesses.
Do we know what their strategy is at the moment, the defense now, because the ball is in their court?
Well, their defense, or rather their strategy at this point, as you put it, is a Section 174 application, which is this discharge application I've just told you about. But you would know that legal aid is funding this particular legal bid, so they would need to know whether or not legal aid will come to the party when it comes to this application. So the engagements are going to be happening between now and next month, the 7th of August, when this trial resumes. They want to know whether legal aid will, of course, fund it. But obviously, there are interesting questions around whether or not this particular application will succeed. Yeah. Looking at the evidence that the state has brought, particularly, I was indicating earlier on that when you look at the issue around the 2 confession statements, in the case of accused number 1 and 2, when confession statements are admitted as evidence, would it be said then that it does not put them in their defense, right? And I'm not saying it's the only thing that one looks at, but there are already confession statements that have been admitted, right? So at this particular point, the court believes they, depose confession statements freely and voluntarily. A final ruling is to be made at the end of the trial itself. You look at other evidence that has been brought, the issue of the gun, the cell phone evidence, you know, the witness testimonies, the statements that have been made under oath, which some of them were being handed up today. You know, the likes of Makeleni, who, you know, pointed out to the fact that this is the people that he saw outside the Khumalo home giving a description which led to the drawing of the identikit of accused number 2. And all of the evidence that really has been presented to the court, can it be said that that particular, you know, 174 application will succeed? We'll only hear at the end of that particular process, when of course they've laid the grounds, they get an opportunity to tell the court why it is in the interest of justice that they be let go, because you know, they would have outlined and pointed out, you know, certain things. I know there's a particular topic that you know, sets social media on fire when you speak about the DNA evidence, which excluded them from being in the house. But also when you look at the evidence that the state has presented in this matter, it's all circumstantial, right? So when the court looks at it, it does not look at it in one particular eye, it looks at it holistically. You know, so one then wonders what lies ahead, but I can definitely tell you interesting times lie ahead, because if this particular application does not succeed, then it means they get to call their witnesses. And we know that they've been complaining about certain people not being called. You'd recall the likes of Kelly Khumalo, Longwe Twala. Will they be calling them to the stand to testify in their case, is the question.
All right, let's conclude the conversation. One of my highlights, really, was the possible recusal of yet another judge when the scandal broke around the current judge and his reference to black lawyers versus white lawyers. And we remember that apology, and some people still hold the view. I was reading a column on the Sunday Times, hold the view that there's absolutely nothing wrong with what Judge Ratamokwatling had said there. And so had that happened, Linda, had this judge ultimately had to recuse himself, would we have gone back to square one, so to speak?
Absolutely, we would have had to go back to square one, the trial starting anew, because it would need to start before another judge. But, you know, when you speak to legal analysts, they tell you that it's not an easy hill to climb. The legal test of recusal is very high, and therefore they would need to satisfy that legal test, not just based only on, you know, just the remarks. What is it about the remarks that makes, you know, this judge unable to continue with this trial? If you're going to argue bias, what is the legal test of bias? So all of that would have to be brought in an application, and all of those set up. But of course, I want to highlight that at the heart of the state's case is essentially that the accused allegedly participated in what the state believes was a hit on the life of Senzo Meyiwa, allegedly ordered by the girlfriend, the then girlfriend, singer Kelly Khumalo. So at this point, the accused are facing these charges, and this is the story of the state, that they were sent allegedly by Kelly Khumalo to, you know, take out Senzo Meyiwa. So again, interesting times lie ahead.
Linda Mnisi, thank you very much indeed, talking to us about a major milestone marked in the Senzo Meyiwa murder trial. And it has been, quite a marathon of a trial.